right. Hi, guys. Welcome back. Welcome back to night 3. Today we're going to be going over Unit 3 and the SCOTUS comparison. So let's get into it. So, Fiveable Crams is night 3. We're going to be doing this to May 5th, and hopefully you guys are learning and enjoying it and studying along with this. Also, follow at Think Fiveable on social media. I saw a few days ago that you guys were interested in becoming student host yourselves. And so a way that you can find more information about that is following Think Fiveable on social media and signing up for their newsletter. So good thing to do. So for our agenda today, we're going to introduce ourselves, we're going to go over the SCOTUS comparison, and then we're going to dive straight into Unit 3, talking about civil liberties and civil rights. And then we're going to go over a bit of discussion questions regarding those contents that we're teaching you. And then we're going to go a little bit over practice questions to help you guys prepare for the exam. So some community agreements. You guys are vets by now, so just be supportive of each other, lift each other up, be patient. We have 2 more nights to go with each other, and be kind because we're all real people here. In order to make the most out of a cram finale, take notes. You don't have to write everything down. This is recorded, so you'll be able to go back to it if you need to. Use mnemonics, questions, a study to-do list. Really organize yourself to get the best out of this. My stuff on Fiveable on our site has the slides, the review packet, and replays that you guys may need to follow along. And then you also see the group chat, which is like the little 2 message bubbles that are on top of each other. And that's great for sharing tips and tricks and participating when we ask you guys questions. And so we also have a Q&A tab for any questions that you guys may have. And we will have breaks, and there's going to be a replay right after this if you guys have missed anything. And so today is May 3rd, so we're going to go over, like I said, the Unit 3 and SCOTUS comparison analysis. And just so you guys know, I'm Kayla. I am one of your student hosts, and I'm come from California, and I'm also a UCLA student. So I would like to hand the mic over to my other co-hosts so they can introduce themselves.
Hi, my name is Demi. I'm a senior, and a high school senior, and I live in Providence, Rhode Island. And I'm excited to see you all today.
Hi everyone, excited to be back for night 3. We're almost halfway there. I'm Sandra. I'm a sophomore at George Washington University.
Hi guys, I'm Amara. I am a senior in high school. I'm from Boston, Massachusetts, and I'm excited to see all of you guys today.
Ignore the extremely loud background, but hi guys, my name is Danny. Sorry about that. My name is Danny. I'm a junior in high school. I took AP US Government last year, and I'm so excited to be here with you guys.
All right, so just to give you guys an overview of the AP Gov test. So our first section is going to be the MCQs. You have 55 questions, and you have an hour and 20 minutes to do it. This ends up being 50% of your score. You also have a second section, which is 4 FRQ questions. It takes you an hour and 40 to do this, and this is also 50% of your score. Today, we're going to be focusing on question 3, which is the SCOTUS comparison. And the other questions are question 1, basically concept application, question 2, quantitative analysis with data, and question 4, an argumentative essay. And so for the units, we went over in our past sessions, Unit 1, which is the foundations of American democracy. This had a total of 15 to 22% of the exam weight. We went over Unit 2 yesterday of interactions among branches of government, and that translated into 25 to 36%. And then today we're going to be going over Unit 3, Civil Liberties and Civil Rights, which is 13 to 18%. And then Unit 4, which is American Politics and Ideologies and Beliefs, which is 10 to 15%. And Unit 5, Political Participation, which is 20 to 27%. We're going to be going over Unit 4 and 5 in the following sessions after this session. So civil liberties and civil rights, which are 13 to 18% of the exam. So we're going to quickly go over the SCOTUS comparison. So we suggest that you use 20 minutes to do this. And what the question is going to be asking you is to compare and contrast information from a case that you already know, which is the required Supreme Court cases, to a non-required case. And they know that you don't know the case, but it's very similar to another case that you've learned about, that you'll be able to figure out how the two are connected. And when you're going through this SCOTUS comparison, you want to make sure that you include the year, the decision, why the Supreme Court justices came to that decision, which is basically the rationale, and the constitutional principle that goes with the case. Make sure to include all of that in your answers to make sure you get all the points that you need to succeed. And it's really important to know to review the differences between identify, basically what it is that they're specifically asking you, describing it, basically what is happening within the case, and explaining it, basically explaining the impact that the case has had within U.S. Gov history, and in terms of keywords that will be used in the questions. So we're going to do a bit of practice here with the passage. And the question is, I'm going to go over and read it to you guys. It's the Seattle School District operated a school choice program that allowed parents to choose the high school they wanted their children to attend. Because some schools were much more popular than others were, the school system wanted to make sure that their schools had diverse student bodies. So it used race as one of the tiebreakers when deciding who would get to attend the schools most in demand. And parents involved in community schools versus Seattle, which happened in 2007, the United States Supreme Court found that the school district was using race in an unconstitutional manner in its assignment plan. The decision was a 5-4 split on the court, with both sides claiming that their position was truest to the precedent set in Brown versus the Board of Education in 1954. And so we're going to give you a little bit of time to go to answer these questions in the chat. And so the way that the SCOTUS comparison works, right? So it splits up into 3 of these small questions, and in total you're supposed to get 4 points. It all adds up to 4 points, right? And so basically you're asked to respond to all questions of all parts of the question, and in your response you're supposed to use examples when they're appropriate, right? So like we just went over, for A, it says identify the clause of the 14th Amendment that is most relevant to Brown v. Board of Education, which happened in 1954, and parents involved in community schools versus Seattle in 2007. B says explain the similarity in the facts between Brown v. Board of Education and parents involved in community schools versus Seattle that led to similar holdings in both cases. And justices on the Supreme Court take seriously, and C, justices take the Supreme Court justices on the Supreme Court take seriously their duty to interpret laws and the constitutions as fairly and accurately as possible. Despite this, explain how sharp disagreements can occur on the Supreme Court about race, how race can be used in school assignment plans. So we're going to give you a bit of, we're going to give you a chance to basically outline what your answers would be for this, and then we're going to go over it strategically to make sure that you guys understand how to approach this type of question within the AP exam. So I'm going to give you guys a few minutes. And also in terms of, do you have to say the year? it is best to say the year, like basically saying Brown v. Board of Education 1954, because it is really important when it happened, because the Brown v. Board of Education happened during the Civil Rights Movement, and it was a key case for the Civil Rights Movement. So it is very important to include the year in there. That's a great question. And thank you, Amara, for putting the passage in the chat. And also, I agree with Daniela. Really keep it short. They want a really quick and concise answer. So just make sure you're answering it thoroughly and as short as possible. I'm seeing some answers for A in the chat. And in my opinion, from my experience of taking AP Gov, the SCOTUS practice is one of the easiest questions because they kind of give you the information and basically help you understand and interpret the case. And then after you guys answer the questions, me and one of my fellow co-hosts are going to go over this with you. Because I see a lot of correct answers in the chat. And you guys are doing really well.
I'll join you, Kayla, for the discussion. And then here's my dog that you guys were asking for earlier. This is Vader. He's a bit of a yapper, but we are pro-yapping here. So that hopefully he doesn't talk too much.
And also, for a quick thing, just so you guys know, look through all the questions before you start, because you may, like, for the identification part, you may, like, kind of, like, yap a little bit more and, like, actually accidentally do the explain part. So make sure you go through all the questions before you start.
Yeah, and it was like I was saying in the chat, be sure you are aware of what the question is do specifically. If you were here last night, I'm not sure if you remember, but in part A, identify, remember to keep it brief, state what it is simply, point blank. That shouldn't really be any more content. And the explain or describes question and go a little bit more into depth. With describe, it's more so what is going on or what is happening, and then explain is why something is happening and bringing in more evidence. So that's where you're getting your bulkier 3 to 4, 3 to 6 sentences. But if it says identify, keep it straight to the point.
All right, it seems like you guys have gotten basically all the answers for our little practice here. So I'm gonna go over some parts, and then Daniela can go over the rest of them. So for task A, you guys are completely correct. It is the Equal Protection Clause. And so just to give you guys a little bit of background, in case you guys missed it. So the 14th Amendment basically grants citizenship and equal civil and legal rights to anyone who was born into the United States or who has become a citizen of the country. And so this was created because after the Civil War to include freed African American slaves, because prior to this, the slaves were considered property and they didn't have any rights. So this established the rights for them. And the Equal Protection Clause basically required states to have equal protection for every citizen, basically not discriminating against any citizen based on their race, their gender, or anything else, just basically protecting everybody. And like you guys were right for task B, both something that's similar within both cases is race. While Seattle was using race to integrate the schools, Brown v. Board Education demonstrated that race was being used to exclude Black students from white students. And then I'll let Danny take over from there.
Okay, again, sorry for the background noise. And then part C, justices on the Supreme Court can take seriously their duty to interpret laws and the Constitution as fairly and accurately as possible. Despite this, explain how sharp disagreements can occur on the Supreme Court about how race can be used in school assignment plans. So immediately we're seeing how Unit 2 can play into this, specifically with how the justices in the Supreme Court work. So remember, if you have justices and judges in the Supreme Court that are of different parties, like I saw that some of you were saying, there are going to be more disagreements. If you have a more liberal judge or a judge that takes more judicial activism, their own personal interpretations of the Constitution and their own personal opinions can affect how this is a big factor. And then those who are very rigid and do not stick to judicial activism will go so by what the Constitution is saying. These answers are really beautiful, by the way. Yeah.
And also another tip for task C, basically like Danny said, it's going back to what we talked about, like one of our first and second night, of loose constructionism and strict constructionism. People who are conservative are more likely to be strict constructivists. Basically, they interpret the Constitution on basically what it says, limiting federal power. And then loose constructivism basically gives a little leeway in what the Constitution is saying and gives more power to the federal government in order to help our citizens. So basically, that's what the prompt is asking for. Liberal judges are more likely to favor an active role for the government, and conservative judges are more likely to limit the role of the government. And that, like Danny said, it causes a clash. So yeah, you guys did really well. Have faith in yourself. You guys are going to crush this.
Yeah, also, we did give you only like 3 minutes to brainstorm, and some of you guys are coming up with full length sentences of answers. So if you weren't able to do it, do not fret, because some of these answers are really good, and this was just to get you guys brainstorming on how you would answer these questions in the scenario of the actual exam. So Kayla, do you want to keep screen sharing and go on, or should I screen share?
I'll let you screen share.
Okay. While I get that set up, I hope everybody is doing well. I hope you all had a glass of water before this. You were taking deep breaths. We are going to get through this together. This is one of my favorite units, so I am so happy you guys are here with us tonight. And let's get started with concepts. So, the foundation of the Bill of Rights. So the Bill of Rights are your first 10 amendments that are part of the Constitution of the United States of America. This was very much pushed for by James Madison because, we're coming from a tyrannical leader, King George III. We don't want a government that has a federal government that has a lot of big power at first, which was one of the weaknesses of the Articles of Confederation, that states had more power. But one thing of the Bill of Rights being included into the Constitution after it was ratified was to make sure the sorry about the background noise, the rights and liberties of the individuals and the people of the United States were protected. So, like it says here, the Bill of Rights enumerates liberties and the rights of individuals. So this is its specific function. And one thing that you should be able to distinguish very well is the difference between civil rights and civil liberties. So one very important distinction between these two is civil liberties more so focuses on the individual and the government not encroaching upon the rights of the individual and those specific liberties. And then for civil rights, that is protections against discrimination. So for civil rights, think more like demographics on race, gender, religion, things like that. And then again, the Bill of Rights is continuously being interpreted by the courts. And like we were discussing last night in Unit 2 with the judicial branch, based on the kind of judges you have in federal courts, you're going to get different interpretations. If you have a judge that is more rigid and is having more strict constructionism, as Kayla was saying earlier, you're going to get a point blank point blank interpretation of the Constitution. So whatever the Constitution states is what they are going to go by, and there isn't a lot of wiggle room. Meanwhile, if you have someone who is more liberal and takes a more flexible approach to the Constitution, it can be interpreted in many more ways, and it's more liberal in general, and they could also have a bit more of judicial activism in that, and how those and how the Bill of Rights are interpreted. But these are the 10 amendments you need to know. And in the Bill of Rights, today we are going to focus mainly on the first, the second, the eighth. But your Bill of Rights will include the first one, your freedom of speech, which is RAPS, religion, assembly, press, petition, and speech. Your second is your right to bear arms. Your third protection against quartering of soldiers. Your fourth is your protection against unreasonable searches and seizures. Your fifth is the right to due process of law and your protection against self-incrimination. The sixth is the right to a fair and speedy trial. It is also a right to an impartial jury. Your seventh is right to trial by jury in your civil cases. Eighth is protection against cruel and unusual punishment, which we're going to go more into. Ninth is the enumeration of all these rights. And the 10th is that powers not delegated to the federal government are reserved to the states. And I know I said that quickly, but yeah. Am I frozen for anyone? I'm waving my hands. Can you guys see me? So I know some of you can say that you can still hear me, but can you see me? Okay, I'm gonna move on. Sorry, I saw the chat, but yeah. So yeah, that's what I defined earlier. So civil liberties, think more, protections for the individual, civil rights, protections for the group of individuals. Okay, like we were saying earlier, one very important aspect of the First Amendment is your freedom of religion. And it says here, freedom of religion, the interpretation and application of the First Amendment's establishment and free exercise clauses reflect an ongoing tension between government power to make law and an individual's right to religious freedom. So I remember last year for the SCOTUS comparison, what's it called? For the SCOTUS comparison last year, there was one question asking, identify which First Amendment clause is similar to both Engel v. Vital, and I believe it was Simmons v. Harris, something like that. But that was the SCOTUS I received last year. And as soon as I walked out of that exam and Twitter popped up, which, by the way, guys, don't post what's going on in your AP, but Twitter popped up and most certainly was talking about the debate whether it was the Establishment Clause or the Free Exercise Clause. So that is something important to distinguish. So the Free Exercise Clause is essentially the right for someone to practice their religion as they would like to. And the Establishment Clause prevents the United States from, or the government per se, from establishing an official religion of the country. So that is something to be wary of, because at least last year for my exam, that was a very big thing. So like I said, the Establishment and Free Exercise Clause, Wisconsin v. Yoder and Engel v. Vital are two examples of both of these. Wisconsin v. Yoder, I believe, is a free exercise clause, and then Engel v. Vital, like I said earlier, was an establishment clause. Engel v. Vital dealt specifically with the idea of just, once again, the government not establishing a religion, because in Engel v. Vital, what happened is that it was held unconstitutional that public or school-led prayers could not be occurring. That is not a thing, because that is promoting one religion over the other. And then you have Wisconsin v. Yoder, which was the idea of the Amish students being entitled to practice their religion as they please. I believe it was passed after the 8th grade. And then you have First Amendment freedom of speech. The Supreme Court has held that speech, including symbolic speech, nonverbal action that communicates an idea or belief, is protected by the First Amendment. And symbolic speech can be many different things. So symbolic speech can literally be me wearing a shirt that says a vulgarity. It can be the burning of a flag. It could be the wearing of an armband, if that sounds familiar. But this is a very another important aspect of your freedom of speech. And then, like I said, if you recognize the wearing of the armband reference, that is a reference to Tinker v. Des Moines, where amidst the Vietnam War, John Tinker and a few of his friends did wear black armbands to school, of which after they were suspended. However, it was held by the Supreme Court that the suspension was unconstitutional under the idea that students do not lose all of their rights at the school gate, and that even though an idea may not exactly be popular, it is everyone is still entitled to their freedom of speech. So your First Amendment efforts to balance social order and individual freedom are reflected in interpretations of First Amendment that limit speech, including time, place, and manner regulations. So time, place, and manner, it's more so, let's say you have, I don't know, a political candidate that is giving a speech, and like a few blocks away there is a riot going on, and this riot is pro something that your political candidate may be against. Because of this time, place, and manner, it may be held that that riot can be unconstitutional because of how far or the proximity of where the political candidate may be given its speech. That's the biggest example I can think of time, place, and manner. But as it says here, that definition is just such limits on the time of day an event can be held, limits on where the event can be held, and limits on the noise levels at an event. Limitations on obscene and offensive communication. This is very limited. Well, obviously it's limited, but this is very subjective, I meant to say. Especially, I know art is a very big example. At least I am a dancer, and wait, let me get into this. I'm a dancer and I go to a performing arts school, and for something I had to perform, the very end of the piece, we had to stick up the middle finger. And with my dance dean, she had an issue with it at first, and her and my choreographer went back and forth for many days. But at the end of the day, what had happened was that the middle finger portion of the piece was still allowed because it was considered artistic expression. In other scenarios, this may not necessarily be allowed, but in the case of my choreographer, it was allowed, and that most certainly was included in the piece. Were my parents happy about it? No, but... And then, wow, I just clicked it and it didn't go. Protections against defamation. Language that harms the reputation of another, including libel or slander. This one's pretty straightforward. If you say something out loud that isn't true about someone or hurts their public image, that can be limited. Or if you write something about someone's image and that can potentially harm them, that's not constitutional. So that's why one of our things is be kind in the chat, guys. We don't want any libel going on in here. My camera is frozen. I'm so sorry about that. I'm just gonna move around again. I'm glad you guys can still hear me though. Okay. Okay, and then you also have clear and present danger, which this was a test that is established within the First Amendment, which is a clear and present danger test. There are several cases that kind of go within this, but when you think the clear and present danger test, think of these examples specifically. Let's say you're on an airplane and someone decides to get up and yells, "I put a bomb on here." And you just by that can already imagine the actions that you are going to that you're going to get out of that. People are going to start screaming. People are going to start crying. It's just going to be like a big unnecessary reaction out of a threat of violence. So that is something that is unconstitutional in terms of freedom of speech, because that does not pass the clear and present danger test. Another common example of this is yelling fire in a movie theater. If you just go in there and yell fire, it's going to have that same big reaction of a threat of violence, and that is not protected by the First Amendment. Yes, like Amara is saying, the case did establish the clear and present danger test. Okay, so this was established through Schenck versus United States. And in Schenck versus United States, this was the case where you, wow, I just lost my train of thought. I am so sorry. So Schenck versus United States happened where Schenck decided to send out papers opposing the draft, which at the time went against the Espionage Act. And essentially what had happened was the whole debate was about whether or not his speech could be limited or should not be limited. And it was ruled how it wasn't patriotic, and in war times causing, such a distraction would not be helpful because of the Espionage Act. And then again, you have the idea of symbolic speech, that nonverbal action that communicates an idea or belief. I'm not sure if I had said this earlier, but like the shirt example, the arms example, symbolic speech could also include money, because money can contribute to symbolic speech, and money can contribute to certain beliefs, and therefore money can be considered a symbolic speech. And again, this idea was, well, not the idea of money. I think the idea of money as symbolic speech was like Citizens v. U.S., one of that case, I believe, if I'm not mistaken. But the idea of symbolic speech was established through Tinker v. Des Moines with the black armbands. And I just clicked the wrong button again. Okay, so First Amendment has the watchdog role. You have censorship issues, you have prior restraint, and you have freedom of the press. So New York Times versus U.S. So essentially what happened in New York Times versus the United States, you had the release of the Pentagon Papers, which was pretty much showing this was showing what the United States was doing. It was sort of, exposing what the government was doing in times where a lot of people did not know. And the government tried to censor the New York Times, but it was held that the press can expose, the government, and it did not have the power to censor the press. So this was the big case in establishing freedom of the press. So if there's one thing to take, wow, I cannot speak today. If there is one thing you should take away from New York Times versus US, it should be that the government had their power to the government's initial power to censor the press was taken away through the because of the instance with the Pentagon Papers. Okay, so we are going to do another SCOTUS practice passage. If one of my hosts wants to join, that's perfectly fine. If not, that's too. I'm going to read it to you guys, and then we are going to essentially do what we did last time. We're going to do a SCOTUS practice. So, Cantwell v. Connecticut. Newton Cantwell and his sons, who were Jehovah's Witnesses, went door to door in a New Haven, Connecticut neighborhood to distribute pamphlets about their religion and encourage people to join their church. The men did not have a permit to solicit door to door. A Connecticut state court convicted the Cantwells of violating an ordinance that stated no person shall solicit money, services, subscriptions, or any valuable thing for alleged religious, charitable, or philanthropic cause, unless such cause have been approved by the Secretary of Public Welfare Council. Cantwell and his sons challenged the conviction, arguing that they did not need to obtain a permit because their activities were protected by the United States Constitution. The Connecticut Supreme Court upheld the conviction, finding that the statute was in the public interest and it was protected against fraud. The Cantwells appealed to the United States Supreme Court. In a unanimous decision, the Supreme Court ruled in Cantwell's favor, holding that the United States Constitution prohibited states from making laws like the one in the question in New Haven. The court reasoned that the First Amendment gives citizens the right to believe, as well as the right to act on those beliefs, and regarding the right to act, laws may not deny or limit the right to preach or disseminate religious views. So, based on this, you guys are going to identify the First Amendment clause that is common to this and Wisconsin v. Yoder, which we just spoke about, and then explain how the facts in this case and Wisconsin v. Yoder resulted in similar holdings. And then explain how the facts in this case illustrate the court's need to balance government power and the rights of citizens. Usually we have a 5-minute timer on this, but I'll give you guys about until 7:40. Y'all are quick, and I'm already loving these answers. What's it called? Just a reminder, I know some of you guys are just like listing it out, and that is what I told you to do, but remember that everything does have to be in full sentences. Nothing should be written out in bullet points. And I know some of you guys are answering in the chat, but just as a reminder on the test to write it out.
Yeah, like Danny mentioned, it's really important to not only know these amendments, but know the clauses. Because as you see, like with all the examples that we've shown you today, that the clauses play as much importance as the amendments. So really focus on that. I've seen in within the chat that you guys have gotten the correct answer, and that's free exercise clause. Remember, the free exercise clause is basically people's right to exercise their religion freely, unless it causes harm to anybody, which in this case, it really hasn't. So, yeah.
Remember, once you're done with part A, you can go ahead and move on to part B. But yes, this is a free exercise clause. This was the, if I said free religion, would that pass on the test? Unfortunately, it would not, because specifically they are looking for the name of the clause. So make sure you do know that. Free religion is a good way to remember it, but know the official name of the clause. Good question, Annalise. Should we explain the clause or just name it on the test? So, like I was saying earlier, if it asks you to identify, all you're going to do is name it in a full sentence, and that's it. If it asks you to identify and then explain, then you can go on to explain what the clause is and how it works in theory. But if it just says to identify, you can just say the clause that is similar to both of these cases is, and then say. You guys have about 2 minutes, and then I'm going to go over B, and then Kayla, if you'd like, you can take C. But far, these answers look great. You guys are chefs. Like, trust, you are not cooked for this exam. Like, if I were here last year, like, I probably would have not been able to do this, if I'm being completely honest with the time constraints. But, yeah. Yeah, and I agree with Amara is saying. Establish what it explains in the required case, and then explain how it is given, how it's similar to the given case. So in those explain questions, you should always define and then explain. You guys have about 20 seconds left. I know it might be difficult, but if you can, try to get to C. But I am seeing a lot of Bs, and this is looking really good. Got 3 seconds. Okay, so B, explain how the facts in Wisconsin v. Yoder and Cantwell v. Connecticut resulted in the Supreme Court issuing similar holdings in both cases. Essentially, you know, the holding in the facts of Wisconsin v. Yoder dealt with the ability of the Amish parents and the Amish students being able to exercise their freely without interference of the school. And then in this case, it talks about the door-to-door situation, and both of them are under the free exercise clause for that reason. And that did rule in their favor for both cases. Just the idea that because their religion is not inhibiting on the freedom of anybody else and they're not harming anyone else, they do have the right to, you know, practice their religion. So, Kayla, would you like to?
Yeah, so for C, they asked basically explain how the facts of Cantwell versus Connecticut in 1940 illustrates the court's needs to balance government power and the rights of citizens. And so based on what College Board is showing us, they would want examples that include like talking about how in Cantwell the court basically wanted to balance the government's power with like the citizens' right to freely express their religion, and part of their religion was to go around door to door. So basically, they want you to talk about how basically there is a balance. They want to balance out how the government can control how one is exercising their religion.
Yeah, perfect. And just so you guys know, and I just forgot what I was going to say. Lovely. It was about the identify, describe whole thing. Explain how the facts of Cantwell. Maybe it will come back to me. It's lost. I lost it. I was going to say something about another method of answering the questions, but you guys did a very good job. Oh, this was what I was going to say. Like Kayla had just explained, and this is something Amara was also explaining last night, there's a certain set of answers that College Board deems to be acceptable. So there is no right or wrong, with an exception of the identify questions. Those are usually asking for a specific name, a specific law, a specific amendment, a specific concept, and you should be able to name them under the impression that you do know what they are talking about or what they are asking for in the question. So those are the situations where you do have to have a specific answer, otherwise you will not be receiving a point. But for like B and C, for example, there is a little bit of room for flexibility. But like we were saying earlier, when it is asking you to explain a concept, define what the concept is, and then go on to show what is happening and why it is happening. But that is essentially it, and you guys did really good for only having 5 minutes for SCOTUS practice. So we are going to move on to the Second Amendment. So the Second Amendment, the way that I remember it at least, because I said remember first, the first RAPS, you have religion, assembly, press, petition, speech. But your Second Amendment, there are 2 ways. I get it too. No? Okay. Two, you can make gun rights, which is more of a contemporary interpretation of it. And then 2 is also to arms. You can bear arms. So like it says here, the original intent of the Second Amendment, which is the right to bear arms, was more for individual rights. But contemporary-wise, or like modern day, a lot of it deals with gun control. And this is another thing with the whole idea of how much of our rights do we give over to the government for our safety versus how much of our rights we retain for the sake of our own liberties. So this is a whole thing between, the idea of should we give up more power or should we retain more of our power in the context of the right to bear arms. And I continue pressing the wrong button to move on. Nice. Okay. So that is the Second Amendment, and Demi is going to go on from here. So I will stop sharing.
Hi everyone, just give me a second. I'm about to screen share. Wait, hold on. What is going on? Wait, is it not like full screen? Can you guys see that? Okay, you can see. Okay, great. In mine, it doesn't look full screen. I don't know why. Okay, but whatever. It should be fine. Okay, great. Hi everyone. We're gonna go over civil liberties and public order. So basically, like, there's the balancing act, which is just over time just a balancing between individual freedom and societal safety. So with this, I always think about like gun control, for example, balancing um the Second Amendment right, the right to have a gun in your home, self-defense and protect yourself with, I mean, we have a ton of mass shootings, we have a real gun control problem here, school shootings and stuff like that. So how do we find the balance between protecting individual rights and ensuring the safety of the public? We've also have ton of case studies for this. So like the Patriot Act's implications. So the Patriot Act, we're going to talk about this again, but after 9/11, Bush was basically like, hey, we need to really do something about terrorism in this country. So this was to protect against terrorism abroad, but also terrorism here, because basically he was like, oh, like, I don't know who we can trust here. Any of you guys could be plotting right now. So surveillance on phones, tons of data, like all your data, the government has that. They have access to all the information about your life. So the government's always watching us, basically. So like the USA Patriot Act really established all of that. And it's like, how do we balance the right to not have my data in the government's hands versus, oh, we need to make sure that this country is safe and we can catch anybody who's plotting before they even are able to carry out that act. And then also COVID-19 public health mandates. There was a big debate over this. I remember 2020 COVID. So people were like, oh, I don't want to put my mask on. I'm anti-vax. I don't want to get vaccinated. But then for the general public, for elderly people, for people with autoimmune disorders, like, you're putting people's lives at risk because you don't want to put your mask on. And it's like, oh, but you have a right to do as you want, but also we need to make sure we protect the public. So how do you balance that? And then also there's the constitutional tests of strict scrutiny and then intermediate scrutiny. So basically, strict scrutiny is used when a law is it's really important. So for a law to pass strict scrutiny, the government has to prove that it's really important and absolutely necessary. So like, let's say for example, let me think. Like, okay, let's say the US and Brazil, for example, are at war. And then a bunch of people are saying, oh, the US is evil. We don't need, like, the US is doing evil things. This is bad. But we also need people to fight against Brazil to protect the US national security interests. So then that would be kind of like Schenck versus the US with the handing out of drafts of pamphlets and saying, hey, don't join the draft. Basically, it's a clear and present danger thing for strict scrutiny. And for intermediate scrutiny, it's more like something that's uh, less necessary, I guess. So, for example, let's say they say women, okay, women get to retire at 60 and men get to retire at 70. And like, okay, that's not fair generally. But then let's say well, the government would need like a really good reason to promote that, and that would be more intermediate because it's not as life or death as like a clear and present danger, basically. So then we'll go over the amendments, balancing individual freedom with public order and safety. So court decisions defining cruel and unusual punishment involve interpretation of the Eighth Amendment, which basically says like you have the right to be free from cruel and unusual punishment. And then there's debate about the Second Amendment, gun law, and the Fourth Amendment, which basically says that you have the right to, you have a right against like unreasonable search and seizures, and includes concerns about public safety and whether or not the government regulation of firearms or collection of digital metadata, which is like the Patriot Act, promotes or interferes with public safety and individual rights. So then we also have selective incorporation that basically applies the protections of the Bill of Rights to states through the Due Process Clause in the 14th Amendment, which says basically that states cannot deprive individuals of life, liberty, and property without due process of law. So that basically means that it's kind of like the supremacy clause thing with federal government versus state. Like what the federal government upholds applies to the states in this case. Wait, hold on, let me see this. Oh, McDonald, but yeah, so McDonald versus Chicago, basically that was a case in Chicago where Otis McDonald, he was like an elderly, something year old black man who wanted to have a fire gun in his home, or handgun, I think it was, in his home to protect his family because he lived in a dangerous neighborhood. People had broken into his house multiple times, and he was like, "Hey, like I need a gun to protect my family." And Chicago had pretty strict gun laws at the time, and they didn't want that. So then it went to Supreme Court, and they said, "Hey, we have to uphold the Second Amendment here." So that squashes Chicago's law of like gun restrictions. And then there was Gideon versus Wainwright. So I'm sure you probably all remember because every time I think of this case, I just think of the guy's face with the glasses. Basically in Florida, he had broken into like a pool hall or something like that, and they pretty much arrested him. But he couldn't afford legal counsel, and so it was just like the Sixth Amendment, like you have the right to legal counsel, even though in normally it had only in previous cases it had only applied to federal like criminal cases, but in this case like it applied to state criminal cases too because of selective incorporation. So due process, the right of the accused. So procedural due process requires that government officials use methods that are not arbitrary when making and carrying out decisions affecting constitutionally protected rights. So basically, it protects the government from it protects the government from doing things. From looking through our wait. Like there's certain policies and procedures that the government has to follow. They can't use methods that aren't arbitrary when making and carrying out decisions. And then there's the Fourth Amendment protections, which is like the unreasonable searches and seizures, and it protects against warrantless searches of cell phone data. So like as I said earlier, the Patriot Act, and then the USA Freedom Act, that was like in the 2010s, I think 2015. Basically, with that act, that restricted the scope of the Patriot Act. So it put limits on how much information the government has on us. And then there's the Fifth Amendment protections that protects against self-incrimination. So, I plead the Fifth. And then double jeopardy, which basically means that you can't be prosecuted for the same crime twice. And then there's the exclusionary rule, which is basically that the government can't break rules when they gather evidence or like do a search without a warrant. And if they do that, that evidence can't be used against you in court. So like, for example, if, I don't know, you're at school, right? And you left a book in your bag that's your friend's. And so then the government comes in, they look through your stuff and they see that book and they're like, "Hey, we're going to charge you because you stole this." But then it's like, "Oh, you didn't have a warrant. You have no, this evidence has no legitimacy because you broke the law in order to gain this evidence." So that's basically what the exclusionary rule is. Then Sixth Amendment rights, which are the right to speedy trial, impartial jury, and the right to counsel. So Gideon versus Wainwright. And then Eighth Amendment standards, so you are free from cruel and unusual punishment. Then there's privacy rights evolution. So there are unenumerated rights. Basically, the Ninth Amendment states that there are rights that are not listed in the first 8 amendments. So one of those is the right to, it's on this, oh yeah, the right to privacy. Basically, in Griswold versus Connecticut, 1965, that established privacy precedents. So there was this law in Connecticut that basically said that couples can't use contraceptives, and that's a very odd law. And Estelle Griswold, she like worked at a Planned Parenthood, or I think owned one, or like was a leader of one. And she was like, "Hey, that's kind of weird. You can't say like couples can't use contraceptives. How would you even enforce a law like that without infringing on someone's rights, like without violating someone's privacy?" And so basically that case went to the Supreme Court, and that established the right to privacy, because that's kind of an implied right in the Bill of Rights, that you have the right to privacy. And then Roe v. Wade extended this right to privacy to abortion decisions, that basically said a woman's right to choose, and a woman's like her control over her body is like her right to privacy. And then there's social movements. So civil rights protect individuals from discrimination based on characteristics such as race, national origin, religion, and sex. And these rights are guaranteed to all persons under the Due Process and Equal Protection Clause of the U.S. Constitution, as well as acts of Congress. So historical movements, the civil rights movement during the Jim Crow era, 1960s, there was a big fight for civil rights and against segregation and for equal rights. So you remember the bus boycotts, the lunch counter protests, the big marches, March on Washington. Then there was the women's suffrage movement, 1920s. Susan B. Anthony, you probably remember those names like from APUSH or other classes you've taken. And LGBTQ rights with Stonewall riots. And then legal milestones was like Brown versus Board of Education in 1954, which basically protected which basically ended segregation in schools. And then there was I don't know how to pronounce it, versus Hodges, basically that said same-sex marriage is legal. You can't discriminate based on sexual orientation. And then grassroots advocacy versus legislative action. So there's multiple routes to get rights. There's grassroots advocacy, and I think of that as people power versus political power. Oh, am I moving too fast? Oh, my bad. I'm sorry. If there's something that you want me to go over again, I can definitely do that. But yeah, so there's the different paths to rights recognition. There's people power and political power. So people power is like protests, or like as you see going on in the world right now, for people coming together to create collective action to move like an agenda forward. And then legislative action is like political power. So that's doing a testimony at the state house, even running for office yourself and saying, hey, like I'm not seeing the representation I need here, so let me step in and try to help my community in this way. Ooh. And then there's a letter from Birmingham Jail. That's actually on the next slide, so I'll go next. But letter from Birmingham Jail was written by MLK in 1963. He was in jail for civil disobedience and the work he'd been doing to end segregation. So he basically wrote to dissociate separation between the ideologies and the separation of segregation. Basically, he argued that he critiqued the idea that segregation is necessary in any way, or that separate but equal was even a valid term. And segregation is harmful to both the oppressed and the oppressor. So he wanted to disassociate segregation from the idea that had any kind of legitimacy at all, that like there was any reason that it needed to happen. And he had a hope for the future. He wanted this vision to be dissolved and for all people to be recognized and to have equal rights. And he was optimistic that there was a hope for the future and a better society where people are treated equally. And because America was seen as this land of opportunity, in a lot of ways it still is, and equality, like how can you have opportunity without equality? And then he also believed that it was a time for change. So he demanded change not just amongst the people in Birmingham, but all across America. And these white moderates and religious leaders have been saying like, "Oh, you should just wait. You should wait." But he was saying like, this has been happening for years. Like slavery has been a part of this country longer than it hasn't been. So slavery, the KKK, Jim Crow, and all like the literacy tests, even like all the systemic ways that Black people have been oppressed in this country. Like he was just saying, like, we're not waiting any longer. So we're going to do this non-violently. We're going to use civil disobedience, but we are going to get the rights that we deserve because we deserve to be treated like everyone else. So that's basically what he argued through this letter. And then these are just like examples of government responses to social movements and how things changed as a result of people power and of political power. So basically, first of all, there was a Civil Rights Act, and then the Voting Rights Act, and then Title IX. Oh my gosh, sorry guys, I'm a little bit sick. But Title IX basically prohibited sex-based discrimination in education programs or just like anything that got federal funding. Like you can't discriminate against women in education programming. Oh yeah, Civil Rights Act just said no discrimination, no to discrimination. Voting Rights Act said no to these literacy tests or like how many pieces of bubble gum are in this jar. Like you can't do that and say you can't vote unless you know the number. Like those kinds of tests. And then judicial action. So the Supreme Court has a big role in affirming or limiting civil liberties. And honestly, like the way the court leans, because it's leaned Democratic, it's leaned conservative, and that has had oh, do you want me to go over Title IX again? That's basically just against same-sex discrimination in like different programs. So like if an activity receives federal funding, like you can't say women can't do this, men can't do, like it can't be like that. Wait, where was I? Hold on. Oh yeah. So the court leans like left or right. Like really decisions honestly depend a lot based on who's on the court. So yeah, their interpretations of the Constitution sometimes limit or restricts certain rights. And also like the precedent has a lot to do with it too. So the balancing rule, decisions demonstrating that minority rights so they've been restricted at times, protected at other times. So if you think of like the Dred Scott decision versus the 14th Amendment, the Dred Scott decision basically said like, hey, formerly enslaved people or Black people in general are not citizens of the US. Like even though you were captured here, brought here, and enslaved, like you are not citizens here, so you do not get the same rights that are in the Constitution. And then that versus the 14th Amendment saying like, oh, you do have all these rights, basically. So they've been restricted at times and protected at other times from in the Supreme Court. And just in a democracy in general, it's important that minority interests are protected. That was something that was discussed a lot when they were discussing like elections and voting, like the founding fathers, because it's important that it's not just the majority that's heard every single time. Everyone's voice needs to be heard. And then affirmative action policies. Basically, affirmative action was put in place by Lyndon B. Johnson. After, I think it was like the year before or after, it was like in the 60s, 65, I'm pretty sure. Basically, to help this group of people that had been disadvantaged so much, to help them get to the same level. Like in a speech, he said, "You do not take a person who for years has been hobbled by chains and liberate him, bring him to the starting line of a race, and then say you are free to compete with all the others, and still justly believe that you have been completely fair." Like they had been oppressed, and subjugated to this unfair treatment for so long that it didn't make sense. For so long that you couldn't just say, "Oh, this is equal playing ground," and you have the same rights or the same access to opportunity. So that was the whole point of affirmative action, to say, "Hey, like here's a leg up, so you can," because you can't compete where you don't compare. If your situation doesn't compare at all, and the rights and given to you through history hasn't compared at all, then how are you supposed to, So that's why that's existed. In on college in colleges, in workplaces. And it's been controversial because a lot of people don't believe it to be fair, because they think like, oh, like all of that, like that's over. Like that's not people don't realize that these systemic disparities still exist today. And so they just think, oh, like all these people are just getting kind of like a free ride there. Like it's not fair that they have a better chance than other people. And in a lot of ways they don't, but yeah, so it's been controversial, and then that got overturned because of the way the court leans. So they're just saying like, oh, like you can't say because of this person's identity or because of the struggles that their family and ancestors have had, like that they deserve to have like that little bit of a leg up so they can compete. So that's why it's like been overturned. So yeah, it's just kind of a controversial thing because like things have, yeah. And then there's voting rights challenges. So there's gerrymandering, which is basically redrawing the lines in a way to benefit, like politicians redraw the lines, the voting district lines to benefit their party and make it harder for minorities to have say in elections. So it's easier for one party to like overrule, one party to rule rather than another. So like, yeah. And then voter ID laws, which require people to show specific forms of ID to vote, which can affect minority communities who may have less access to these IDs. And also, there's voter suppression as well. So like having very not that many polling places, so then there's long lines of people who have to wait like their entire day in order to just put their ballot. Um, so there's that. And voter ID law, like honestly, getting your ID is expensive sometimes. Like I remember I was going to Maryland, and I think I had to pay like $50 or $60 to get my state ID. So if someone's in a low, like someone like doesn't have that kind of money to spare to get like an ID, then I mean that's already put them at a disadvantage in being able to vote. So voter suppression happens in a lot of different ways. So there's still voting rights challenges today. So these are some discussion questions. How does the First Amendment protect individual freedoms while ensuring a stable society? So I'm gonna like give you a second to answer. If I'm sorry if I went too fast, like if you need something to be re-explained, like please say in the chat and I'll look at it. Oh, okay. I'll go over grassroots advocacy versus legislative action. Basically, like I said earlier, it's just people power versus political power. Grassroots, like organizations, nonprofits, like doing that work of coming together and doing this collective action to push forward a campaign. So, like protesting is an example of people power. Um, or just like I'm trying to think of other examples, but I feel like protesting is the biggest one. Like walkouts out of school, That's an example of people power. Or in Tinker v. Des Moines, like the black armbands, like that's an example of people power. People coming together, and using like symbols to or like protests and signs to push something forward. And then for legislative action, that is um like political power. So that's running for office, or that's lobbying, or that's like just going directly to like talking to your representative, or going directly to politicians. Like that's more political power. But yeah. So basically everyone, I guess we'll go over the first question. I don't see that many responses, so I'll give you another second to answer. But how does the First Amendment protect individual freedoms while ensuring a stable society? That's the question. Oh wait, I'm seeing a lot more responses. Yeah, I like these. Yeah. Yeah. So through like freedom of speech, freedom of press, freedom of religion, I'm seeing that. Yeah, yeah, I like these responses. Yeah, so basically through using the well, the freedom of speech, being able to say being able to petition, being able to hold the government accountable, being able to like the press's ability to just say whatever they want to say, without being controlled by the government or without being suppressed. That is part of protecting individual freedoms, and that's ensuring stability and ensuring that our democracy survives. Freedom of religion as well, like um, being able to practice whatever you want, like just the freedom aspect, like that is protecting individual freedoms. But of course, there's limitations, like as always. Next question is, how has the Second Amendment's interpretation evolved over time? Yeah, I like these answers. This is really good, guys. Yes, 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 yes. I really like these answers. So yeah, basically at first, the Second Amendment, American Revolution, that whole era, basically it was the states needed to protect themselves at all times, because they were a newly formed nation. The British were still after them, and it was important to them that at any time they could have their guns in their houses and pull it out and be blah 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 if a threat came to their little towns. So yeah, the whole point of it was a need for a militia to protect against external threats. And then it was more like, yeah, it was more of a focus on the collective rights of the states. But now it's more of a individual right. Like, oh, I have the right to have a gun in my home to protect from everyone else. Or I have the right to hunt. Or what else do you do with guns? Yeah, I guess like hunt or protect your home using a gun. So yeah, so that's what the Second Amendment means more now. That kind of individual rights. And yeah, so there's the DC versus Heller case. I don't know if you guys remember that. It's not a required case by any means, but it's just like a good one to know. basically it held up that the Second Amendment protects individual rights at home, because DC had this like full ban. They were like, oh no, no guns around here. And then these people sued. They're like, hey, like I have a right to bear arms. Was it Helen? No, I don't think it was real. Okay. um yeah, so basically they were like, yeah, I have a right to for yeah, to have guns in my home. And the court was like, yeah, yeah, you do. So that's how it was. um so the next question is, discuss how selective incorporation has extended pro- civil liberties protections at the state level. Yeah, I at first for some reason I didn't register that was a joke, and I was like, what the heck? But yeah, I see it. I want to see more answers. Selective incorporation. Remember, guys, like the federal stuff applying to state level. Oh yeah, so the selective incorporation, like before, like I said, basically applies to protections of the Bill of Rights through the due process clause that like we all have. The due process clause is basically saying that states can't deprive individuals of life, liberty. Um, I was about to say pursuit of happiness, but I think it's property. So that's pretty much what the due process clause is. That that consistency has to exist no matter where you live, like in all the states. Like everyone has the right to due process under the law. And then yeah, basically selective incorporation just applies that protection um, to the state. So like I think, what example did I use? I forgot what was on the slide. I think it was probably like Chicago, the McDonald versus Chicago. That uh well like that Chicago had like this had restrictions on guns, and basically the government is like this, and they were like Second Amendment rights. But Chicago was like, oh no, this, but this like supersedes this supremacy kind of. So yeah. So that's selective incorporation that like yeah, I don't know if I'm explaining that right. Yeah, I guess we can go over the question now, discuss how selective incorporation has extended civil liberties protections at the state level. So basically, it's expanded rights across states. So before that, um, the protections in the Bill of Rights only applied um, to actions of the federal government. So like the states were infringing on certain rights, but like with selective incorporation, it's like, oh, you can't infringe on those rights because the federal government, like because of selective incorporation, yeah. And then it just protects freedoms and it limits state power, because it's kind of still like a balance of federalism, federal, power of the federal government versus the power of the state. So selective incorporation is basically saying like the um, the federal government, these rights, like you have these rights federally, so that applies to the states as well. It's not that state rights supersedes in the case. So like McDonald versus Chicago, or in the case of it was like, was it Oberfeld? No, it was that one case before Roe v. Wade that, let me go back, that allowed for the protection of, wait, hold on, the right to privacy. Oh yeah, Griswold versus Connecticut. No, this is not the state. I don't know what case. But I remember there was a case in Texas. Basically, Texas had this like near pretty much total ban on abortion, and or was that, I don't know, but yeah, it had a protection, had a ban on abortion pretty much, and through um the federal government like right to privacy like that, like maybe, yeah, this probably is Roe. I'm probably describing Roe, but yeah. And then the next question is evaluate the balance between national security interests and individual rights in recent U.S. legislation. So the balancing act. Hit low is not required. Honestly, I don't fully remember. Recent, I would say like the past 5 years, 6. No, actually, I'd say like 10 years. Or no, actually, no, I wouldn't say that. I would say like 2000 up. I would say that that's recent. Personally, if they said recent, I would say like 2000 up. Oh, the balancing act, it's not like an actual like act. It's just like the balance between individual rights and protecting national interests and national security interests. Like we mentioned before. Oh, actually no, I won't say what that, because I want to see what you guys have to say. But just how do you balance between national security and individual rights? I'm not seeing any answers. What's going on? Oh, you guys are probably typing. My bad. Yeah, actually, I would count like the war on terror as in like 9/11 and stuff. Yeah, I would count that. Like 2000s and up. Like how do you balance? Think of what I said earlier. I'll give you a hint. Like this is me on my phone. Oh, I like the answers I'm seeing. Yeah. Ooh, yeah, quarantine minute. Yeah, I like what I'm seeing. Yeah, I would just honestly count anything after 2000. Well, actually, yeah, like after 2000, I would say like 9/11 would count as recent. You don't have to use a specific act. You can describe just like, well, I think with like 9/11 and the war on terror, like there were things that came with that, like if even if like airports and security and the Patriot Act. Um so I would mention acts to go with that. Yeah, I think Vietnam was a little long ago. I mean, I would still take that answer, but I don't know about college board. Yeah, I would say the Patriot Act is a good example. I'll go over it now because, yeah. So Patriot Act, that was in response to 9/11. It expanded government surveillance programs, and just like their intelligence gathering and data. So the government is watching us at all times. They have access. If you're on your laptop right now watching me, they know what you're doing right now. Basically, like, well, yeah, to an extent they do. If you remember Snowden and the National Security Agency surveillance programs, like he exposed all of that and he was like, "Hey, um the government literally has all your telephone metadata. They see all your internet communications. Um like prote- uh in order to prevent terrorist threats." So basically, it kind of shows that the government doesn't really trust us because they're watching us at all times to make sure that we are not plotting against them. So protecting against domestic terrorism, basically, or like making sure that people aren't plotting. Um, so yeah, so I would say Snowden because that was like 2010s. I'm pretty sure like that was pretty recent. I would say if you talk about um, that balance between surveillance and um, protecting individual rights, because the Fourth Amendment, like unreasonable search and seizure, the fact that they have access to all this data. I mean, we're still checking those long, instead of reading the long things, we're still checking it off and giving them access to our data. But at the same time, like our individual rights. I mean, in that sense, we're giving up our individual rights, but there's still like a kind of an unfair balance in that sense. Snowden ran away. Like that they were after that man. They were after him. He was like, "Shoot, like I cannot be here." I think he ran away to Russia, and I still think like if they caught him today, like, they would go after him because this was a big breach. Like this was a quote data leak, you know? So the fact that the whole public knew that, hey, the government's watching us, like that's not something they want people to know. That's a clear and present danger. Thankfully, he was able to run away. He's a citizen of Russia right now. So, yeah. And then also, I would say an example I just thought of are the travel bans. Like, not even during COVID. I think it was like during Trump. Like, he was like, we don't want people from Muslim countries coming here or something like that to protect national security interests. I don't fully understand why. Um, I don't know. I don't remember why, but I just remember that there were travel bans saying like, "Oh, you can't come here." I just remember seeing like videos of that. Oh, that's so cool. You protested. Yeah. Oh, I see something about college. Yeah, 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 yeah. Yes. About the protests going on in college campuses. Yeah, for sure. Because they want to protect the national interest and continue to um be on Israel's side, and they don't want to hear any kind of objection to what's going on in that situation. So yeah, let me see if I see other examples. Oh yeah, vaccines, mask mandates, yeah, individual rights versus national protections. So yeah. And then the the next question is um oh okay, it's the last question. How have social movements historically impacted government policy regarding civil liberties? Oh yeah, customs regulations. Yes, absolutely. Yeah, for that last question. Like the way airports and TSA and everything was completely changed after 9/11, protecting the national security interests versus the individual rights. Like you have to take off your shoes and your socks before you can get on the plane. Okay, I like the answers I'm seeing to the next question. Just to repeat it. Oh, did it? Oh, it went black for me for a second. I don't know if you guys saw that. Okay, yeah, I'll just repeat the question. How have social movements historically impacted government policy regarding civil liberties? Yeah, I'm seeing some great responses here. Yeah, African American rights, civil rights movement, boycotting, yes. Brown v. Board, women's suffrage movement, yes, yes. I think I saw something about Title IX up there. Voting Rights Act, yes. Affirmative action. Yeah, this is all great. So yeah, civil rights movement, the March on Washington, boycotting, just everything, the bus boycott, like that was huge. Like these kinds of big collective actions and people coming together to yeah, there was a movement during Vietnam War. Like there were a lot of protests and the press helped. Well, I completely cut myself off. Oh my gosh. I'll go back to the civil rights movement and then I'll mention the Vietnam War. Um so yeah, the civil rights movement, um bus boycotts, people coming together to and then that helps greatly impacted government policy, and it pressured the videos of the March on Washington and the videos of the police brutalizing these people pushed for government policy to be taken. So that was pretty big. Vietnam War, because I think that was the first war that was recorded on film. Like there were people were watching from their homes, like what was happening in Vietnam, and that pushed for change for sure. And the Pentagon Papers and everything like that, like just hearing about when people saw what was really happening, that caused a big um uproar. So like just the press plays a big role in all of this. And women's suffrage movement, yes, I saw that. People protesting and coming together, definitely. And also, one that people don't talk about a lot is like disability rights advocates. So like they've done a lot, honestly, to make just navigating the world easier for everyone in general. Like if you think about ramps and like before you cross the street, like the thing with the bumps, like here in Rhode Island, like there's like these things with bumps and that are yellow before you cross the street. There are more ramps, more elevators, more like it just makes the world more accessible. Yeah, American Disabilities Act is definitely another example. Yeah, LGBTQ rights, Stonewall riots, women's equality. Yeah, this is great. You guys definitely got this for sure. So with that, thank you all so much. I'm gonna move on. Wait, we're gonna do a break first, because you all deserve a break from all the hard work that you've done. So thank you so much for listening in and participating. Really appreciate it. And so you guys can all go to your break, and then we'll come back in 5 minutes to go over SCOTUS practice and do some um, multiple choice questions, like a cram quiz. Okay, great. Oh, and make sure you do the poll before you go on your break. Bye.
Hey guys, welcome back. I hope you all had the time to take a nice little 5-minute break. Demi, you can stop screen sharing. And we are actually going to go ahead and do a cram quiz. So we are going to practice some multiple choice questions. Ignore Vader scratching at the door. We are going to practice some multiple choice questions regarding Unit 3. And I will share the link with you guys right about now. I'll share it in the chat. And it should be a call to action as well. I'm not sure if you guys can see it. Will another dog reveal be happening tonight? If I can get to the door and back within the given time frame that we have. But now your cram quiz should... And yeah. Wait, let me put the music since you guys love it. Oh wait, it just ended. Oh, wait, sorry. Ooh. Okay, let me wait until you guys start. Yes, samosa. Yes. Yes. Very enthusiastic, yeah. I'm gonna wait until we try to get to about the 50 to 51 people. Yeah. Hope you guys are having a good night. I hope you guys are content. If you didn't do it before we left, great, go ahead and yes, Kahoot does stuff with their games. I prefer some. My screen is lagging a little bit, so I'm gonna stop sharing for a quick moment and then share it. Sorry about the technical difficulties again. Trust, these are what's it called? These are nothing compared to but yeah, go ahead and join the cram quiz if you haven't already. I am just refreshing my screen because it is frozen right now. And she refuses to move. But it's okay because we persevere. Here we are again. She is loading. I don't know if by doing that, no, you could still join. Okay, I have about 29 participants and there are like 50 of you in here. No, it's okay. I can still share again. It was just my screen. So I'm gonna wait for some of you to join and then we do have to start. But since we do have time, I'm gonna wait for you guys to join. It's just that we're missing about 20 people. And I will share again. There we go. And there's a little chili pepper. You guys have also been doing very great so far in the chat with your answers, with both Demi and Kayla. I am guys, and I'm sure the rest of the hosts are proud of you as well. If you can't find the link is there in the chat. Just Amara just posted it. And under me, there should be a little call to action button that's like in green, like a statue of color green that says cram quiz. So that should be there. I'm going to wait until 45, approximately a minute. Then I'm the quiz, which we are missing about 70 people. Please join. But those 20 people count myself and Kate. So I suppose that is 15 people. You guys have about 30 seconds. We will play. I'm sorry about the fact that you cannot use it. I don't know what is going on. But there she is. So, which of the following is prohibited under the First Amendment of free speech? Come on, you got this. I know you got this. Remember, this is a very, very easy question. But if and then go have to choose that would just like a year ago. Oh, I have 25%. I have increased stats as on Tuesday. Oh, not ready for that. Okay. Waiting on 4 people to answer. Oh, the number just went down. I'm gonna give it 5 more seconds and answer. Okay. Ooh, okay. So B is the correct answer. Censorship by the government is prohibited under the First Amendment's protection of free speech. This censorship by the government, remember, was established in New York Times, the papers, and freedom of the press. The censorship by the government is prohibited because freedom of the press. Many of you, yes, it's very good music. Many of you put C, making false statements to harm others. Yeah, I could see why that one is what's it called? That's very confusing. What is prohibited under the First Amendment's protection of free speech? A would not be prohibited. Technically, D would also not be prohibited because of like the time, place, and manner thing you have going on. Making false statements that harm others' reputations. That falls under slander and libel, which is included in the First Amendment. Do any of my other hosts have a potential answer for this? Because the wording is a little off. Yeah, that's what I'm talking about. C can also kind of fall under the whole thing of time, place, and manner. Amara, you want to go ahead and take this?
Yeah. So this is another one of those like best answer sort of questions. So the thing about censorship by the government, you can think of it like the press. If you guys remember New York Times versus the US, right? In that decision, the Supreme Court basically said the government can't censor the press unless like it's absolutely necessary. If it's just something that they don't want the press to like post, they have to have like a solid reason for like safety issues. But if not, they can't censor it. So censorship by the government is prohibited under the first, unless, it's something like sending out like military codes and positions in times of war. That you can censor. Anything else you can't. By making false statements that harm others' reputations, it is prohibited, but it's also not really, because I can say something about, let's say, like the president or something on like a news site and I won't be censored, right? I can still do that. That's legal for me to do. I might get sued if it's very much false, but it's not necessarily prohibited as much as censorship. So C is the most accurate and the best answer for that.
Yeah, thank you so much. That really helps. And now that you said that, it's more so of like, which is annoying, but AP does tend to do this. The best answer for you to have on the exam, and I guess because B refers to the freedom of the press and the idea of how the press can release what they want to say because of the case of New York Times versus the US, it does make B the best answer. But it does show you guys know your stuff because, like, you know, see into like potential. It's just that so happens that in this case, B is the best answer. And thank you so much, Amara, for joining me on that one because I did need help on. So next question. Is symbolic speech. Funny thing about me, I don't remember, but earlier I did say I am a dancer. Maybe not social, but I can do ballet and I can do contemporary, but you put me in a social setting and I'm totally cooked. It's really bad. You guys are getting this one fast. Okay, we are waiting for 3 people now. Emily, that's awesome. Go ahead and do the answer in 5, 4, 3, 2, 1. Okay. 4% actions that non-verbally express political viewpoint. Very, very good. So once again, symbolic speech or speech in general does not have to be that written or something that loud. And established by Tinker Coins and the whole idea of John Tinker and his friends and the group of students wearing the black armbands with the peace symbol on them. That was symbolic speech. The burning of flag can be symbolic. Me wearing something on the t-shirt, the finger I told you guys I was sticking up in the dance the other time, that is symbolic speech. Is fairly written or said. Like I said earlier, it can also be symbolic speech because of what it can contribute to. So yeah, wow, 94%. You guys are cooking. And then B and D, the other ones for the other people who did choose it, written statements automatically because it says written at the beginning of that statement, which I guess I understand why someone might choose B, but because symbolic speech is necessarily like the definition of it, something that isn't written or said, B. And then D, symbolic gestures made during court proceedings. That no, it's just not that one. It's C. So next question. I'm gonna think of the dance story about this test. Guys, feel free to use my personal anecdote for your art day if it has to do with free speech. I don't know why the music goes away sometimes and then it just sporadically comes back. It's so odd. So remember just to read each of the questions. I mean, wow, nice. Each of the answer choices carefully and eliminate the ones that are absolutely ridiculous before you go ahead and choose the one that you think is right. And I'm going to reveal the answer in 3, 2, 1. Yes! Okay. So Tinker Des Moines affirmed that students don't lose their constitutional rights at the school gate. So that's essentially what Tinker v. Des Moines was about. The students were suspended, taken to their report, and that was the decision that SCOTUS went with. Students have speech, and because right to speech under the First Amendment, it just goes to show that we don't lose all of our rights, although we give up some for our safety. That is not one of them in the case of Tinker v. Des Moines. A and D were the other ones that were frequently put. So A, it established the right to protest against government. We, as the people who up of government, have the right to protest anytime the government is doing our right to protest. So it wouldn't be A. Protesting is sort of what John Tinker and the group of students to accomplish by wearing the black armbands, but that is not the significance in relation to the First Amendment. And then D, it led to the separation of church and state and schools. Tinker v. Des Moines is not a religious landmark case that you need to know. The two religious cases that you need to know for the AP exam are Engel v. Vitale and the Establishment Clause, and Wisconsin v. Yoder, which is the Free Exercise Clause. But Tinker v. Des Moines is a First Amendment case in the realm of symbolic speech. And yeah, just like Amara was saying, B is more specific to the case, while A is more general and like the facts of the case. Next question: which action most effectively ensure force in line with First Amendment rights? Oh my God, yes, sir. Just a little hint and a little tip. Whenever you see anything relating to papers or journalists, automatically relate that to press. So that helps you decide your answer with it. So anything like this, like the New York Times.
Okay, so far, can you guys? We got changed. Give me 1 second. Come on, it's gonna work. Don't worry, guys. Give me like 1 second. Danny, are you all good?
Yeah.
Okay,
Yeah.
I can stop sharing if that's easier for you.
What do you want? I don't mind.
Okay, so I can continue and then you can explain and then.
Yeah, sounds good. Okay, yes, which action in journals? Wow, identical. And we're gonna go ahead and reveal the answer. Yes, okay. Reporter's privilege. So the one a lot of people tend to put here is C, limiting reporting to non-controversial, agreed upon facts only. Okay. Say like, how would I explain this? I feel like this one is a little bit of common sense. The whole thing with the journalism is, wait, hold on, let me be a little bit of a nerd for a second. It's getting your ideas out there, and the idea of just like trying not to be controversial is not necessarily a thing, because no one necessarily, well, you can intend to be controversial, but not everyone goes in with that intent. So obviously whenever you are writing something, you should use what's it called? You should use the correct sources, and using confidential sources in this context is what would most align with the First Amendment. Now connecting it back to Gov. This one is a bit of a tricky question, but again, this one is more of a reading question, I would say, instead of a concept question. So I can understand why it was a little harder, but yeah. Let's go on to the next question. So which political ideology is most likely to support a strict interpretation of the Second Amendment, emphasizing individual gun ownership rights? I wonder. And we really haven't gone over political ideologies yet, so if you don't know the answer to this one, it's okay. A-okay. We touched on them, but really we're going to get more into that tomorrow and in Utah. Alright, we're going to move on to 1. And it is D. Conservatives are most likely to support a strict interpretation of the Second Amendment, emphasizing individual gun ownership rights. So, yeah, you guys got this one. The only reason that it wouldn't be liberal, the thing with this is that in the case of the Second Amendment, liberals tend to have more of a thing of government regulation over things like gun ownership, while conservatives are more like wanting this individual right, even though generally speaking, when it comes to social issues, conservatives do want the government to intervene more. But the Second Amendment and gun ownership rights are one of those things where conservatives kind of want the government to back off a little bit more. But you guys got this. 94% is whopping. Like, y'all are killing it. Alrighty, next question. What impact did McDonald v. Chicago decision by Supreme Court have on understanding of the Second Amendment? You guys are free to look at fun. I'm having fun. 3 is definitely a very entertaining and interesting unit. And we are going to go ahead and review it. 7, 6, 5, 4, 3, 2, 1. Yes. Okay. So McDonald v. Chicago extended the Second Amendment's protections of gun ownership rights to all states. That's essentially the impact of McDonald v. Chicago. It restricted Second Amendment rights only to federal territories and not states. That does not make any sense. They just based on like the way the Constitution is structured and the reasons like we have amendments, you can already like eliminate that answer because that one is a little bit silly. B, the case rule that state laws supersede federal law when it comes to right to bear arms. Okay. The case rule that state law supersedes federal law when it comes to right to bear arms. The reason I would say no to B would be like specifically because the line state law supersedes federal law. That never happens. State law will not supersede federal law. State laws have reserve powers that the states keep, and the federal powers have theirs. But when it comes to just anything like this, state law will not supersede federal law. So for that reason, it is not B. And then C, the case was about interpretation of the First Amendment, not the Second Amendment. Not true. Not true. This is a Second Amendment case. So D, 77%. Good job, guys. So we are going to move on to the next question. Yes, good job, Amelie. That is because of the Supremacy Clause. Oh, yes. U.S. v. Lopez. Guys, I don't know how many times I said in the chat today, but that is not NOT, not a Second Amendment clause. I mean, Second Amendment case. And that is something so important to remember, because that will, like, I remember that being a part of so many MCQs on my AP government exam last year. That case is in regards to interstate commerce clause. That is U.S. v. Lopez, not the Second Amendment. Just wanted to put that out there. So, sorry, I forgot to read the question. What does infringed mean in the context of the right shall not be infringed from the Second Amendment? Yes, Amara, like just like I was saying, like U.S. v. Lopez is interstate, and the Commerce Clause, not Second Amendment. All right, we're going to reveal the answer in 5, 4, 3, 2, 1. Yes, 90%. You guys are killing it. So in the context of the Second Amendment, infringed in the context of the right shall not be infringed means violated or encroached upon. So not only for the Second Amendment, but for all amendments in general, just remember the whole idea of the Bill of Rights and amendments is so that that individuals keep their civil liberties, and that's what this whole unit is about. So when we're talking about infringed, we mean like the rights of others or our rights being violated upon or encroached upon. So for that reason, none of you put A. Very good job. So it's not A, it's not B, and then obviously it would be C. So it would be D. And the next question, we have about 3 more questions. Which protocol item is most important right to the government? Another little political ideology question as well. Again, we'll go into this more but just for you guys. I just played this one. Remember the minutes? Janet, how long did it take you to make that? I don't know neo-conservatism as well. I don't know it that well either, so I will pull up an official definition for you and try my best to explain. So it says here, neoconservatives typically advocate the unliteral militaristic and realistic socialist philosophy of peace through strength. They are known for espousing opposition to communism and political radicalism. Well, I'm guessing neoconservatives or conservatives. So that would be something. I don't have control of the thing now, but thank you, Amara, for lowering the music. It says here that conservatism is a political philosophy that advocates for the promotion of democracy and interventionism throughout international affairs with using militaristic means and opposing communism and political radicalism. That is the official definition. I will try to break down if any of the other hosts can break down neoconservatism better than I can, but usually when you think of neoconservatism, just think of... Yeah, you can go ahead and reveal the answer for this. I'm so sorry, I got a little distracted with that one, but yeah. But the answer to this question is liberalism. So I just lost where I was. Yes, which political ideology is most likely to support the expansion of civil rights through government intervention? Liberalism. I forgot who said it in the chat earlier, but yes, liberals do prefer more government intervention, but that is for the expansion of our rights. What is the difference between liberalism and libertarianism? Okay, liberalism, I would say, is more government intervention, high government intervention in general, more high government intervention though, mainly in economics to prevent corruption from big corporations and big businesses, so like more regulated economy, and then still high government regulation, but less so within social issues and more like open-mindedness to creativity and expression, especially like the expansion of like civil rights and the ideas of sexuality and just like self-expression. And then libertarianism, I believe, is no government intervention in either social issues or economic issues. So just like no government intervention at all. I hope that helps explain. But yes, the answer to this question is liberalism. It was exactly the opposite to that question I threw at you guys earlier to see if you were paying attention. And yes, it's like Amara said in the chat, libertarians go for individual freedom over government. So that is like the big thing to remember with libertarianism. So we can move on to the next question. We have two more. Which Supreme Court used the Equal Protection Clause of the 14th Amendment to challenge and overturn school segregation? Y'all, I hope y'all know this. Please, like the dragon. Oh. Sometimes the music just stops and it makes me... what's it? I fear. Okay, yeah, let's go ahead and review the answer for this one. I am not connected. And I think I'm back now. Okay. Yes. 100% that is Brown v. Board of Education. I don't think I have to explain. This is the first time we have gotten 100% on a cram quiz question, which shows that y'all are paying attention. It was a little easier, but it shows that y'all were paying attention. So y'all are cooking. So we're gonna go to one last question, and then we're going to go and do a SCOTUS practice passage. So which piece of legislation was passed as a direct result of civil rights movements advocating for racial equality? I wonder. Ooh, excuse me. Wish there was a way we could come back after the exam course, or just see the overall process. At the end of each of these sessions, you guys can take a poll or like a survey at the end to tell us how we're doing. In terms of like when the exam is actually over, I wouldn't be surprised if there were a survey to go out, or like if Fiveable will send like a little newsletter like asking to see how you did. Like I'm like, I want to say 90% sure they would probably do something like that. Don't quote me on it, but I see that as being very plausible. We could also discuss what was different than we expected. Yeah, definitely. I agree with you guys so much. All right, so we're going to go ahead and review the answer in 3, 2, 1. Yes, 90%. The piece of legislation that was passed as a direct result of civil rights movements advocating for racial equality was the Civil Rights Act of 1964. For those of you who are taking or have taken U.S. history, I'm sure you've heard this before. At least this is something my U.S. history teacher says. All the civil rights movements or the civil rights acts prior to 1964 really don't have as much effect as the one established in 1964. Like 1964 is the one that really did make a difference. Let's say you're in the exam and you really don't know which one of these it is. I'll take you through my thought process. So reading the question itself, it's talking about civil rights movements advocating for racial equality. So automatically you're going to eliminate C, which all of you did, so good job, because it's talking about Americans with disabilities, and here in the question it's asking about racial equality. And then right in the question itself, it says civil rights. So you can eliminate D, and even if you're really reading that into it, you can eliminate B, because A says it right in the name, Civil Rights Act of 1964. Yes, look at the years that these acts were established, because if you do have that historical context in mind and it helps you to contextualize everything, that will be a major help. So that concludes our Cram quiz. You guys did really good tonight. Again, I know some of the questions can be iffy. But yeah, you guys did good. You guys got through it. Unit 3, I believe, is not only one of the easiest units, or easier, I should say, but one of the most fun units and enjoyable. So thank you. Amara, you can stop sharing. Thank you so much for hopping on when I froze. And now we are going to move to a SCOTUS practice passage. So I'm guessing, Demi, you are going to take that over. So I shall leave now.
Hey everyone, we're gonna start with hold on, I gotta share my screen. Wait, is this right? Yeah, there we go. Can you all see my screen? Okay, great. So basically we're gonna go over 2 SCOTUS practice passages. So this is the first one. Zelman versus Simmons Harris, 2002. So I'll read it completely like out loud. In response to low academic performance at public schools in lower income sections of Cleveland, the Ohio legislature enacted a program that allowed the use of public funds for private school education. Parents who showed financial need could obtain vouchers of up to $2,500 a year for tuition at participating private schools. Both religious and non-religious private schools could participate in the program. And in the first year, 96% of voucher recipients opted to attend religious schools. A group of Ohio taxpayers, which included Doris Simmons Harris, filed a lawsuit against the public school system, claiming the use of public funds for religious institutions was unconstitutional. The local federal district court ruled in favor of Simmons Harris. After the Court of Appeals for the Sixth Circuit upheld the ruling, Sarah Zelman, the superintendent of public instruction in Ohio, appealed the ruling to the Supreme Court. In a 5-4 vote, so kind of iffy, on the subsequent case of Zelman versus Simmons Harris, 2002, the Supreme Court held that the public funding of a school voucher program that includes religious schools was constitutionally permitted. In the majority opinion, Justice William Rehnquist reasoned that the program provides benefits directly to a wide spectrum of individuals defined only by financial need and residence in a particular school district. It permits such individuals genuine choice among options, public and private, secular and religious. So just to like summarize, basically in Cleveland, Ohio had this program that allowed public funds to be used for private school education. And then all the parents who were making use of these vouchers were like, oh, we're going to go to religious schools. But then some taxpayers were like, why are these public funds going towards religious schools because the recipients are choosing to go to religious schools? That's not right. It's not endorsing religion. And so it went to the Supreme Court. It was upheld. But then the superintendent in Ohio was like, hey, this is not really about religion. It's just about the fact that the parents chose to go to religious schools. It's not meaning that we're directly putting this money towards religious institutions. So that's basically it. And then the Supreme Court was like, we agree with the superintendent. This is only for financial need. It's not about religion. So then the three questions, well, the three parts that you have to answer are these. So the first one is identify the First Amendment clause that is common to both Engel versus Vitale, 1962, and Zelman versus Simmons Harris. So I'll give you a minute to answer that. And just actually, you know what? I won't refresh you. We'll see how much you got. Oh, you only processed some of that? Okay. I'll just do a quick recap. Basic, or do you want to go back to the last slide? Oh wow, dang. Oh, Amara just put it in the chat. But yeah, I'm seeing establishment clause. Yeah. Yeah. So yeah, I see establishment clause, which is correct because basically, in that case, it was both about religion and whether the Ohio like this program endorsed religion or not. In Engel v. Vitale, basically, it was in New York schools when there was a required prayer at the beginning of class. So it was like Almighty God, da, 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 that every student was required to say at the start of class, kind of like the Pledge of Allegiance. And they said, oh, this is endorsing religion. That's not right. So establishment clause, 100%. So the next question is explain how the facts in Engel v. Vitale and Zelman versus Simmons Harris led to different holdings in the two cases. Oh, it glitched? Wait. Oh, you're glitching. Okay, not me. But yeah, what do you think how do you think it led to different holdings in these cases? What do you see that's different between Engel versus Vitale versus Zelman versus Simmons Harris. Yeah, I'm seeing some great answers in the chat. Yeah, you guys definitely got this. Great. Yeah, I'm loving these answers. This is great. Yeah, so as you guys are all saying, in Angle versus Howe is more of a forced and direct thing. That all these students have to say this, or like this is the kind of the standard. But in this case, it's not really about religion. Like it's not that the government was trying to push for religion. It's just that the people who took advantage of this financial, like not really financial aid, but yeah, I guess financial aid. The people who took advantage of this, majority of them went to religious schools. It wasn't like a direct you have to do this. It doesn't mean that the government's endorsing um anything. And then yeah, so the government was involved in a very different way, and it was in Zelman versus Simmons Harris. It's more indirect and neutral, while in Engel versus Fidel, it's very direct and very clear. Yeah, these are great responses. This is really good. So the next question is explain how the holding in Zelman might affect educational policy in states with legislatures that support the ruling. So basically, what is the impact of um, this case? Like, what would it mean in other states? How might it affect educational policy? Great, these are great responses. This is really good.
Hey y'all, I'm back. But yeah, these are like all very lovely responses. And again, we're just kind of throwing these on so you can get these answered in a very short amount of time. And some of you guys are like throwing like very like lengthy answers. So this is wonderful. This was the FRQ I had to answer because I took this class last year. And like I was saying earlier on, this was the whole thing between on Twitter argument of no, it was the free exercise clause or it was the establishment clause. It was the clause of that was what was in Engleview. This is just I need to know all of the cases, because if you know the or like whatever is involved in what case, you will get your answer to A. And
Danny's waking up for me. Okay. I can't hear like anything you said. It broke up so much. Now I
wait, I didn't realize I'm breaking up. Okay. Basically what I said was just like this was the FRQ that I had last year, and there was a whole argument whether it was the free exercise clause or the establishment clause. And it was the establishment clause, and I was just saying like this is the prime example as to why you should know your cases, because through deductive reasoning you could figure out, like, for example, that the answer to A was the establishment clause, and it can help you answer the rest of the questions.
Yeah. And for the person who asks about how they always have trouble with C, or like the last answer on the SCOTUS practice, I would say just write down everything you know and try to BS it, honestly. Like that's what I did, because last year I took Gov, right? And my teacher didn't go over any of the units. We did not have any standard this is like what we do in the exam, like prospective voting. We never covered that. We never covered like anything that we're teaching you guys. We talked about current events more, right? So I knew nothing. I didn't know any of the cases. I didn't know any of the clauses. And 2 days before I took the exam on that Monday, on like a Saturday, I crammed the entire course. Me and my friend, we crammed the entire thing. We went into the test and we came out with fives because we like literally crammed everything. And Fiveable was honestly a pretty big part in that. So I'm telling you, like when you guys say like, "Oh, I'm cooked," like I don't know anything about this, trust me, like you will be fine. You're doing the preparation, you're putting in the work, and as long as you write down everything you know when you see it, and even just look at the multiple choice from before. Well, you can't look at it from before because it's a new packet, but just try to remember everything you can. Because like what I was doing when I went to the test was I was repeating the cases in my head, and then I wrote it all down on the paper so I wouldn't forget. So just make sure you memorize the cases, the documents. And if anything, just try to infer what you can. Just try to see like what might be implied in the SCOTUS, in the argument essay. Just like try to remember everything you can. And honestly, you will be fine. Like it will be okay.
Yeah.
Sorry.
Trust. Oh my god, Demi, that is so much. That's so loaded. I'm so sorry you had to go through that.
Yeah. And honestly, I mean, the cramming was worth it, so it's like it's okay. But that's why I'm saying like you guys are fine. Like you will be fine.
Not cooked. You guys are not cooked at all. You guys are cooking.
All these answers look really good. They look great. So yeah. Yeah, for sure. Okay. Yeah, being confident, is very important. Just go in there and be like, "Oh, I have this. Like this is it. Like I got it." And you'll be fine.
Absolutely.
So the third I didn't mean to interrupt you.
No, go ahead.
So I'll just repeat the question. Explain how the holding in Zelman might affect educational policy in states with legislatures that support the ruling. You guys have great responses. So what I'm seeing here is that you guys said that other states would mimic this and allow for vouchers to be used for other religious institutions, which is a great answer and would 100% qualify. I think it also like would promote school choice. So with these vouchers, more people would be able to say, "Oh, I'm not going to these public schools. I'm going to use this money and go to a private or religious school." So that would change things as well.
Yeah. That's essentially like I believe that's what I put for this answer last year on the exam, that it would be allowed for the vouchers to be used for both religious and secular schools. You guys are cooking. These answers are so beautiful. right. I think we can move on to
one.
the next SCOTUS practice.
You want to read it?
Sure. Okay, so this is Betts v. Brady, 1942. In 1941, Smith Betts was arrested for robbery in the state of Maryland. Sounds familiar. Unable to afford a lawyer, he was denied a public defender by a judge and forced to represent himself. He was found guilty and given an 8-year sentence. Doesn't that sound awfully familiar? In the ensuing case, Betts v. Brady, 1942, the Supreme Court ruled against Mr. Betts, who claimed his constitutional right to a fair trial was denied. Ooh. In a 6-3 decision, the court held that the right to counsel applied to only criminal cases in federal courts, and that he did not have the right to a counsel in a state court except in death penalty cases. Justice Black, in his dissenting opinion, reasoned, this case can be determined by resolution of narrower question, whether in view of the nature of the offense and the circumstances of his trial and conviction, this petitioner was denied the procedural protection, which is his right under the federal constitution. I think he was. All right. So based on the information, respond to the following. A, identify the constitutional amendment in the Bill of Rights that is common to both Gideon v. Wainwright and Betts v. Brady. B, explain how the decision in Gideon v. Wainwright relates to the reasoning and Justice Black's dissenting opinion in Betts v. Brady. And C, explain how the decision in Betts v. Brady demonstrates the principle of federalism. I think this one was pretty straightforward. What's it called? It's literally structured the same exact way the other one was structured, like almost down to the nitty-gritty. It's just like the context of each of these cases. What's it called? And like you probably noticed me doing while I was reading, you're not supposed to know the case that was given. But as you probably saw, it sounds awfully familiar to one of the cases. So while you're reading it, try to already start thinking of like what potential case is going to be mentioned in your question when you are when you are reading it. So we have it here for right now. So just as a reminder of the question, since we don't have that slide up at the moment, just so you guys can see the text, the first question was to identify the clause that is similar to this case and Gideon v. Wainwright. Then B, describe how I believe it was the outcome in Gideon v. Wainwright was similar to the dissenting opinion. Yeah. And C, explain how the decision in Betts v. Brady demonstrates the principle of federalism.
I see a lot of Sixth Amendments for A, which is 100% correct. The right to impartial jury, the right to counsel. That definitely applies to both cases.
Ooh.
I'll bring back the past so you can see the dissenting opinion, so you can answer.
Amar just put it in the chat.
Oh, great. That works.
Thank you.
Thanks, Amara.
I did see some people saying the 14th Amendment. This is reasons like you do have to pay attention to like the constitutional principles and concepts of the cases, because Gideon v. Wainwright is a Sixth Amendment case. And that did like kind of establish like the right, it didn't establish the right, but it reinforced the idea that you do have the right to legal counsel if you cannot afford one in a speedy trial.
Yeah, due process, like Sixth Amendment just is more applicable and more like, I don't know, like Sixth Amendment, just associate that with Gideon versus Wainwright. Like due process, I mean, sure it applies, but Sixth Amendment more than anything because of the right to counsel.
How would this demonstrate federalism? So remember, federalism is the idea of you have the state level and you have the federal level, and they have shared powers and they have their division of powers. So think of that definition, and then just based on that, Just with the context of this case, how do those two things, how are they interconnected? So how is this concept connected to that case?
Repeat part B. Explain how the decision in Gideon versus Wainwright relates to the reasoning in Justice Black's dissenting opinion in Betts v. Brady. And to go back to the dissenting opinion, it basically just said, this case can be determined by resolution of a narrower question, whether, in view of the nature of the offense and the circumstances of his trial and conviction, this petitioner was denied the procedural protection which is his right under the federal constitution. I think he was. So basically he's saying that, hey, like, this is determined by whether you see this as a violation of his procedural protection, which was the Sixth Amendment, because he was forced to represent himself, found guilty, and given a prison sentence instead of given the right to a fair trial. This was 1942, and then Gideon versus Wainwright, 1963. It was solidified that normally and like it said here, normally the right to counsel only applied to federal courts and federal cases. So this is a selective incorporation case because, well, this isn't, but Gideon versus Wainwright is, because it went from only federal courts to state courts as well. Yeah, I'm seeing great answers here. This is really good. You guys got this. 100%.
Yeah.
Yeah, I would say that you guys are right that this relates, like the reasoning in decision in Gideon versus Wainwright relates to the reasoning in Justice Black's opinion, basically because his opinion was what happened in Gideon versus Wainwright. He basically, in Gideon versus Wainwright, they decided that, hey, like, he deserves the right to counsel. Just because he can't afford a lawyer doesn't mean that he doesn't deserve to have his day in court. And Justice Black basically said that about what was it? Who was it? Betts. So that's how it connects. That's like a very verbal explanation, but I mean oral explanation, but written. You guys are doing great.
Yeah, just remember the whole idea of federalism, just like the shared division of powers between state level and federal level, and in the idea of this case, it's just like, hey, at both the state level and the federal level, we are upholding the Sixth Amendment right of, Betts having his legal counsel, because that is his civil liberty. I get the broad idea of C, but I don't really know how to explain it, specifically selective incorporation. Kate, could you drop in for this one?
Up in 1 second. So I'm gonna go camera on for a rare appearance. One moment. So hi, I'm Kate, your teacher host. You guys haven't seen me yet before, but this is a really important question, and it's important in this case to look at those dates. We've told you before that you don't need to know the dates because they're given to you, but in this case specifically, the Betts case is before Gideon versus Wainwright. So I actually have something that I was writing in the chat. So in Betts, these rights hadn't been incorporated to the states yet. So at this time, states have the power in their own courts to run courts as they see fit. And because this amendment had not yet been incorporated, the states have the jurisdiction over this issue. So basically, in Part C, you can talk about how in Gideon versus Wainwright, more in Part B, in Gideon versus Wainwright, we have the right to an attorney incorporated to the states and expanding these rights and impeding on the idea of federalism and states' rights. But once again, this is like one of those rare cases where these dates make a huge difference. Because if you were in 1941, you wouldn't be guaranteed the right to an attorney if you were charged with a state crime. But afterwards, after Gideon versus Wainwright, you would have the right to the attorney. So I can stay on for a minute and see what questions I see in the chat. So for Part C, again, we're looking for this idea that under the concept of federalism, it's power to organize their own court systems. However, after Gideon versus Wainwright, those rights were impeded. So I'll be here. I'm in the chat. Happy to see you all. And you guys are doing a great job.
Thank you so much, Kate. Hanjun, I hope that answered your question. Yeah. So we do have a survey that you guys should fill out that kind of lets us know how we're doing. There's a call to action at the bottom right about now. That was the last practice quiz we have, but we do have a good, I want to say, hi math, 14 minutes left. So if you guys have any questions or any concepts that you would like us to go over once again, please let us know. And yeah, if you can't access the call to action button, Amara, just put in the survey link in the chat. Thank you so much for that. What's the difference between substantive and procedural due process? Amara, do you want to take that one? Or Demi?
Like I said, I crammed before I took the exam, so I don't remember. But one of the other student hosts can take on that question.
Okay. Hi guys, again. So quick thing about substantive and procedural, the way I remember it is that procedural law, not procedural law, procedural due process, okay? I take law classes, this is why. But procedural due process has to do with like the process of the law. So I gave out like an example. With like arrest, there are certain procedures that the police have to take, you know, give out your rights, you know, arrest you, take you to the station, take your pictures, whatever, and then, you know, trials and everything else. That's procedural law, and procedural due process follows the same concept of there being a process that you follow. With substantive due process, it's just basically stating the law in a way, right? So you can think of substantive as it's substantial, it exists, that's, you know, it's just there. Procedural, think of it like a process. There's a process to go through, there's steps to take. So you can take like the law enforcement example as procedural, and then for substantive, it would probably be like I don't know, if like a state had like a law that says you can't be in jail for like more than like 10 days without knowing what you did. That could be a substantive law that's there. So substantive, it's just it exists and you should follow it. Procedural is that there's processes and there are certain directions that you have to take.
Perfect. Thank you so much. We are gonna go ahead and go over more MCQs. How do you write a proper conclusion paragraph on the argumentative FRQs? Okay, so back to the Cram quiz, I'm just gonna answer this really quickly. In terms of the argumentative FRQs, I don't believe it is absolutely necessary for you to have conclusion point rubric. I think you do need to synthesize. This isn't appealing. You need to use 2 of the foundational documents we're giving you.
She froze for me. I don't know if
not again.
You're back. You're back. Okay.
Okay. Yes, like Amara said in the chat, the conclusion can be the rebuttal for your argument, which you do need.
I think honestly, I would say it depends on your time. If you have a lot of time left and you have time to like synthesize and put together cute little conclusion, I would do that. But if you don't have the time, I would say 100% make sure you have a rebuttal that's part of the points you get for the argument essay. So just make sure that it's just like you're really you came back, I think.
Yeah. But go ahead, continue with what you were saying.
Oh, okay. More frozen than Anna. Yeah, so basically I would say it depends on how much time you have, but make sure no matter what you have a rebuttal and you put in just do what they ask you to do. For the conclusion, I don't think it's absolutely necessary, but if you have the time to, it just always looks good.
All right. We do have some intention. Again, sorry for being like on a frozen, but we do have some intentions to do like a few more MCQ end off the night, unless anybody has, like absolutely lingering questions. Do not let it go. Like, let us know.
Yeah, we're gonna go over we'll do more Cram quiz practice, but like Danny said, like if you have any questions about the exam generally or what it was like taking it, like we can answer any questions. So yeah, I'll put the music on. Oh, is the music not working? I guess not. But I'll put the link in the chat again. Oh, we have a wait, where did you You're back. We have a question. What's the difference between the equal protection in the 14th versus the 5th? Equal protection in the 5th.
So the 5th is the right to due law and protection against self-incrimination by the music. Okay. So like protection against law incrimination, and then the 14th, was it the 14th Amendment that you're asking? Yeah. So Black citizenship, but that's protection of the law. So equal because of due process of the law and the idea we all go through this treated under that. Is there similarity? But I guess in terms of difference, the amendment is more focused in one light, and then the 14th Amendment also includes Black citizenship, if that helps you separate the two.
Oh wait, where's my music? Yes. This was a pretty easy one. Yeah, so women's suffrage movement 1920 led to the ratification of the 19th Amendment. So yeah. So next question.
While we are doing the cram quiz, guys, if you still have any questions left, please post them up. We can answer them while we're doing the quiz, because there are only 5 minutes left. If you are on your way out and you have to absolutely go, thank you for cramming with us on night 3. We hope you had a good time. Make sure to take
Okay, great. Yeah, race, color, religion, sex, or national origin. Yes. Yeah, the Civil Rights Act, that's pretty much what it did. Um, next. Okay, great. Yes, you guys all got it. This is amazing. Yeah, so Ingle Vital basically set this precedent that school sponsored prayer, even non-denominational, violates the Establishment Clause because it can't be endorsed by the government. So yes.
Wow, my camera keeps freezing. But yeah, if you guys have any questions, just let us know. I'm not seeing too many.
Me? Am I frozen? No.
No. I was frozen. I think I was frozen.
Okay. Because someone said it was Demi this time, but no, I don't freeze. So. Yeah.
How has the interpretation of the Commerce Clause evolved over time, and what impact has on the balance of power between the federal government and the states? I don't think it has evolved too much over time. The Commerce Clause, I believe. Yes, please don't forget the survey.
Yeah, I think this is going to be our last question. You guys, majority got it right. 13th abolished slavery, and the 14th granted citizenship to all persons born or naturalized in the United States, including former slaves. So yes, that's great. Thank you all so much. You guys are doing amazing. So don't forget to do the survey. If you have any more last minute questions, pop them in the chat and we'll answer them.
Debbie, do you have a better answer to that one?
Which one? Is it in like the question tab?
Established at least.
Oh, you froze. I didn't hear anything you said.
Okay. I was just saying, do you have anything to add with the interpretation of the Commerce Clause in this question?
With it. Oh, I see on the screen. Huh. I only know like through the cases. Like, you know, the USV Lopez and stuff like that, but I don't really know much about how it's evolved over time. I don't think that's something that it's a good question, but I don't think it's something that you need to know if you're looking for like necessary information because they don't really focus that much on that.
Yeah.
Or maybe last year was just like a really good test because I feel like that was just like a solid like it wasn't too much of um campaign finance or anything that was like hard to grasp. So yeah.
Yeah, I
But
agree.
thank you all so much. It is
Yes, thank
10.
you all so much.
Yeah, Lopez is you're required to know.
Yeah, it is now time. It is 10:01, so this cram is officially over. Thank you all so much for being here with us. We hope you had a great time. Please don't forget to take the survey so you can let us know how we did. And we hope to see you guys tomorrow for night 4 of
Bye. Thank you all so much.